sasalin ang dollar deposits. Sa dami-dami po na sinabi, doon lamang nalimita ang issue. At dito po kami halos lahat gumawa ng desisyon sapagkat hindi naman po namin matanggap na hindi kailangang ideklara ang FCDU account. Bagamat ako po bumoto ng guilty, naniniwala po ako mabuting tao si CJ Corona. Ito ay isang error in judgment. At inuulit ko po na napakataas po ng antas ng integridad na kailangan sa posisyon ng pangunahing maestrado ng ating pong Korte Suprema. Pabayaan niyo pong bigay ko rin ang obserbasyon ko sa mga nangyari noon. Ako'y nalulungkot din na meron tayo, at sana wag na po mangyari sa mga darating na panahon ng illegal na pagkuha ng mga ebidensya ay parang normal o binabaliwala natin. Napakahalaga po niyan sa ating sistema ng hustisya. Napakahalaga ng isang ebidensya na hindi legal ang pagkuha ay hindi pwedeng tanggapin. Sana po, yung mga hindi na maulit, yung mga little lady, yung mga mailbox, mga Mr. Anonymous, yan po, sabi nga ni Congressman Pariñas, mga palusot. Huwag na po sana maulit yan sa mga darating na panahon. At huwag na rin po sana maulit yung walang pakundangan na paggamit ng mga ahensya ng gobyerno. Mahalaga din po na mahalin natin ang kalayaan po ng ating mga institusyon. Yan po ay magpapalakas ng ating demokrasya. Mahalaga po sa akin ang mga bagay na yan. At inuulit ko po, naniniwala ko, mabuting tao si CJ Corona, subalit, dito po sa issue ng FCDU account, nagkamali po siya rito. Naniniwala po ako na dapat pantay-pantay ang implementasyon ng batas na ito. Mayaman man o mahirap, miyembro man ng Korte Suprema o pangkaraniwang mamamayan. Kaya po ako ay bumoto ng guilty.
The Honorable Presiding Officer, the Senate President.
Thank you. Magandang hapon po sa inyo lahat. Unang-una, gusto kong pasalamatan ang aking mga kasama sa Senado na ngayon ay ginagampanan ang katungkulang bilang hukom dito sa paglilitis na ito sa kataas-taasang mahistrado ng ating kastaas-taasang hukuman sa ating bansa na siya ang tinatawag na guardian ng ating saligang batas at ng kalayaan ng ating mamamayang Pilipino. Gusto ko rin pasalamatan ang mga abogado ng dalawang panig nandito ngayon, the prosecution panel, as well as the defense panel, for their untiring effort in participating in ferreting out the truth in this trial, and in order to arrive at a just resolution of the case before us. In the entire course of this impeachment trial, I have faced many difficult challenges to my own and the court's collective wisdom, our sense of justice and fairness, the delicate balancing act we must perform to ensure that we do not stray from the strictures of the Constitution, the laws, and our rules. This trial began and unfolded against the backdrop of a highly charged and emotional atmosphere, acrimonious debates in and out of the confines of this court, and a deep political fissure which threatened the stability of our democratic institutions. But the impact of the many events that transpired since December 12 last year to this very day, taken together, cannot compare to the sense of heaviness that I feel at this very moment. The culmination of this national drama is at hand, and the time has come for me to render judgment on the person before whom I took my oath of office as a senator of this republic, no less than the Chief Justice of the Supreme Court, Renato C. Corona. The respondent Chief Justice and his family understandably feel deeply hurt, pained, and aggrieved. As a lawyer, I must confess that I was personally frustrated, really frustrated, by the loose and hasty crafting and preparation that characterized the presentation of the charges contained in the articles of impeachment. It seems that the case was being built up only after the charges were actually filed. The repeated recourse to this court's compulsory processes to obtain evidence which normally should have formed the factual basis of the charges in the first place further burdened and at times taxed the patience of this court. We have witnessed with disdain the indiscriminate, deliberate, and illegal machinations of some parties who have been less than forthright with this court and its members in presenting dubiously procured and misleading documents which were spread to the media, obviously to influence these courts and the public's opinion. The letter of this administration of the Land Registration Authority, which contained as an attachment a list of 45 properties supposedly owned by the respondent Chief Justice, was fed to the media even before we could begin the actual trial of the case. Even before the Honorable Ombudsman, Conchita Carpio Morales, was called to testify before this court, her letter to the Chief Justice requiring him to explain in 72 hours an alleged aggregate amount of US $10 million in several dollar accounts was leaked to the media right before the resumption of this trial last May 7. We have sternly cautioned against unethical and unprofessional conduct, the penchant to engage in trial by publicity, to use the media to disseminate and advance so-called information or evidence, to provoke and disrespect this court and its members, and to irresponsibly hurl disparaging insinuations and accusations. We have tried to impress upon everyone who may be similarly motivated and inclined to test our will that this court means serious business and would not succumb to or allow such underhanded tactics and gimmickry to deter this court from our task. Prudence and justice dictate that in determining the guilt or innocence of the Chief Justice, we must try our best to confine ourselves to the pieces of testimonial and documentary evidence that have been presented to this court, to pass upon their relevance, and to measure and weigh their value in the light of the charges before us. After all the accusations leveled against the Chief Justice, 8 charges in all comprising the articles of impeachment, the prosecution chose to present evidence only on 3 articles, namely Article Roman number 2, Roman numeral number 2, Roman numeral number 3, and Roman numeral number 7, and then abruptly rested its case. I've always believed that of these three, the case for the prosecution and the defense will rise or fall on Article 2, which is now the subject of our vote. This court, at one point, had extensive discussions and differences of opinion, to be sure, regarding the charge contained in paragraph 2.4 of Article 2, that the Chief Justice was, and I quote, suspected and accused of having accumulated ill-gotten wealth, acquiring assets of high values, and keeping bank accounts with huge deposits. Close quote. We ruled to disallow the introduction of evidence in support of paragraph 2.4, which to this day I strongly maintain, as I'm sure my colleagues in this court strongly maintain, was an invalid charge, it being based on mere suspicion, on so-called reports, rather than on factual allegations. The defense and the Chief Justice himself, unhappily, somehow revived this issue of the nature of his assets by introducing evidence to prove that his income and assets were legitimate, and by testimony to show how he and his wife had saved and invested these savings in foreign currency over so many decades. At this moment, I wish to reiterate, for the record, that the Chief Justice does not stand accused of having amassed any illegal wealth before this impeachment court. Paragraph 2.2 of Article Roman numeral 2 of the Articles of Impeachment accuses the respondent, Chief Justice, of failing to disclose to the public his statement of assets, liabilities, and net worth as required by the Constitution. I submit that the Chief Justice had justifiable and legal grounds to rely on the Supreme Court's procedural and policy guidelines governing such disclosure as embodied in a resolution promulgated way back in 1989 when the respondent was not yet a member of the Supreme Court. Under the said guidelines, the Clerk of Court of the Supreme Court, who is the repository of the SAL-Ns submitted by all the members of that High Court, may furnish copies of the SAL-Ns in his or her custody to any person upon request and upon showing that there is a legitimate reason for the same. The Constitution, in Article 11, Section 17, states that, and I quote, in the case of the President, the Vice President, the members of the Supreme Court, the constitutional commissions, and other constitutional offices, and offices of the armed forces with general or flag rank, the declaration shall be disclosed to the public in the manner provided by law. RA 6713, known as the Code of Conduct and Ethical Standard for Public Officials and Employees, recognizes the public's right to information on the assets, liabilities, and net worth, financial and business interests of public servants, but it likewise declares it unlawful for any person, and I would like to quote the provision, to obtain or use the same for purposes contrary to morals or public policy, or for any commercial purpose other than by news and communications media for dissemination to the general public. Close quotation. Period. Whether the said guidelines violate the letter and spirit of Republic Act 6713 and the principle of public accountability is not, I repeat, is not for this court to pass upon.